Do we have a motion at this time?
Brief discussion first. I have a motion.
Please.
Thank you. It is a it is a phrase in the law or an axiom that hard cases make bad law. I think we can all agree that applies to this case, this situation that lays before us. I think that the General Counsel has made a good job, a tremendous effort into protecting the jurisdiction of this court, protecting our authority, and making sure that there is a record sufficient for the parties to fully litigate this matter upwards on appeal, as both have said that they intend to do regardless of the outcome today. So I commend the General Counsel for that. The General Counsel advises us that if we pass on the constitutional question, we would be exceeding our authority under the election code. And I think it's important to reflect on what that would mean for this board, specifically if we were to do so. If we exceeded our authority and went beyond the documents and the nominating petitions and looked at the underlying conduct that was alleged in this case, what I believe you would see is an opening of a floodgate of litigation, not necessarily before this board, but before all of the electoral boards that look to us for guidance on all the different election matters across the state. The fact is that this board sets the standard, the legal standard and the procedural standard for all the other electoral boards across the state. We're talking about the county elections, the village boards, school boards, and the like. And if we allowed them and gave them authority to say, don't just look at the papers, but actually look at underlying allegations of misconduct, that would open up floodgate. One of the things we've seen over the years in this board is that challenges in these local elections often are the fiercest of any contested case, more so than at the presidential level. And I think that what we would see if we exceeded our authority is every possible school board candidate would seek to challenge the qualifications based on some sort of alleged criminal conduct. And this board and the other electoral boards are certainly not constituted to do so. There was wisdom, I believe, in the legislature when they created the election code and said what our authority was, and by that, what our authority wasn't. And when we all took an oath to serve in this role, we would be violating that oath if we exceeded our authority and weighed into the constitutional question against the recommendation of the hearing officer and against the recommendation of the General Counsel. And also note that in addition, so that the record is clear, I think that the relief that objectors are seeking is one of ballot forfeiture, and under our statute, they simply haven't presented a case for ballot forfeiture as well. So with all of those caveats in mind, that's the rationale in my mind, maybe others have others, but I would move that we accept the General Counsel's recommendation that the candidate did not file a false statement of candidacy, insofar that there is some sort of statement necessary. I think that we do not have jurisdiction to wade into the constitutional issue and to decide the question of whether the candidate engaged in an insurrection in violation of Section 3. Therefore, I further move that we deny the motion for summary judgment, bring the motion to dismiss for lack of jurisdiction, and therefore overrule the objection.
Can I ask one question about the motion? So is the board or is the motion suggesting that Illinois law does in fact require a candidate to not be disqualified by Section 3 in order to appear on the ballot? Or is this sort of an alternative that if the
it's an alternative. It's in the alternative.
It's in the alternative.
Correct.
Okay. Okay.
There's a second.
I make that motion.
Roll call.
Ms. Ballard-Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
I'd like to make a statement before I rule on this. I want it to be clear that this Republican believes that there was an insurrection on January 6th. There's no doubt in my mind that he manipulated, instigated, aided, and abetted an insurrection on January 6th. However, having said that, it's not my place to rule on that today. So I will say yes to the motion as far as not having jurisdiction to rule on that fact today.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.